Namaskar, dear friends. We will take 10 more questions from our series to learn more about our system of governance. Like always, catch the additional parallel learning through the images on the screen. Like here, you see the categorization of aerodynamic flows and flight vehicle speeds using the Mach number. Mach number is a dimensionless and therefore unitless parameter crudely defined as a ratio of the vehicle or flow velocity to the speed of sound. Let's take the first question. It says, how many of the following statements are correct regarding the advisory opinion of the Supreme Court under Article 143 of the Constitution? Now, first statement, it cannot overrule a previous judgment of the court. Now, that's actually not correct because technically speaking, a presidential reference is not an appeal in the Supreme Court. It's not an appeal against a judgment. The court does not sit in appeal. That is to say, a reference cannot be made to get a judgment overruled. That much is correct. However, to answer any question that is referred to the court, if required, the bench can overrule any previous judgment. This is a reiterated opinion in the last presidential reference of 2025 regarding the powers of the governor and with respect to the bills passed by the state legislature. The original opinion on this matter, which is the statement here, was given in a reference, which is the reference for the Special Courts Bill of the year 1978. So, in that, the court has said, and in the recent case also, they have highlighted this, that if need be, they can overrule. So, for example, the court in the recent case also addressed the arguments that the reference was an appeal that seeks to overrule the Tamil Nadu governor's case. Accordingly, the court's opinion stated that an advisory opinion can overrule if necessary. However, in this reference, last reference, no question was such which would have required the court to overrule any previous judgment. So, the statement is actually incorrect. Then a reference made by the president can be returned unanswered by the court. That is correct. In the last reference, also in 2025, there were total 14 questions, out of which 3 were unanswered by the court. They did not return it with an answer. So it is totally possible. Then there have been 16 such references. That's correct. This was the 16th reference. So second and third are the correct statements. And that picture, by the way, is the Supreme Court of United States. Where on the entrance is engraved the motto, equal justice under law. Why I brought it here is to highlight to your attention that there is no advisory jurisdiction of Supreme Court of United States, very much unlike India. There is a similar provision in Canada though. Let's take the next question. Which of the following are examples of equality before the law as it is envisaged in the Constitution of India? Now, see, equality before the law, which is a British concept, most simply means the law treating all persons the same. So, statement 1, which says prohibition on discrimination by state on the basis only of religion. Now, this is definitely equality before law. Nobody can be discriminated because of their religion. Second says schemes of the government that aim to empower only women. Now, this is incorrect. Schemes to empower women. So that is not equality before the law, as women will be given special treatment. This is precisely what is equal protection of the laws, which is a US concept. Third says reducing the cutoff marks for candidates belonging to backward classes in the exams for public employment. The logic is same as the previous one. This is another case of positive discrimination. So this is also incorrect. This is not equality before the law. So only one is the correct answer. Almost half of us could get that. Can be better. Fundamental principles. Next question is reservation provided in favor of which of the following classes of citizens is considered vertical reservation? Now, see, what is vertical reservation? It is that reservation that is provided for social justice to backward classes of citizens and other weaker sections also. And these are exclusive categories of reservation, whereas horizontal reservation is for those groups that have some additional disadvantage, such as disability or social ostracization of transgenders, women, etc. And these are not exclusive. These are not exclusive, and they cut across all vertical categories of reservation. See, the best way to visualize it is how the civil service exam result is also published by the UPSC, which I have brought it on the side here for you. You can clearly see the vertical reservation here. All these categories, they are the vertical reservation. And the horizontal reservation, which cuts across all the vertical categories, all of them will be found. So, for example, here where it says the first category PWBD, people with benchmark disability. So, while in general PWBD will get, in EWS, OBC, SC, ST, everywhere we have to provide reservation. Why it is nil here? Because the seats are so less. In cyclical method, 1 year one category, other year one category. It's like that they will create, or there may not be vacants. So many candidates as well. So this is the idea of vertical and horizontal reservation. So EWS is a vertical reservation category, whereas transgender and women, they are not vertical reservation, they're horizontal reservation. Okay, so transgenders and women are horizontal reservation. Then, next question says, how many of the following statements are correct regarding provisions related to reservation for backward classes of citizens in educational institutions and public employment? First statement, the provisions for admissions in educational institutions states the nature of backwardness. That is correct, because it does say socially and educationally backward. I'll bring the provision up for you in a moment. The provisions for reservation in public employment does not state the nature of backwardness. That is also correct. It does not state actually. Let's see these provisions. So first, in the Article 15, if you see clause 4, it does say that a special provision for the advancement of any socially and educationally backward class of citizens. So it is defining socially and educationally backward class of citizens. Whereas if we see 16.4, in 16.4 it says provision for the reservation of appointments or posts in favor of any backward class of citizens which is not adequately represented. It is just saying backward class. Unlike Article 15, it is not explaining the type of backwardness, social and educational backwardness, or whatever else. So 15.4 states the nature of backwardness. 16.4 does not state the nature of the backwardness. So both these statements are actually correct. Then the third one says reservation in education institution is a fundamental right. Reservation in public employment is a fundamental right. Now both these statements are incorrect. None of these two are right. These provisions which are there for reservation 15.4, 16.4, or even others, these are only enabling clauses depending on the state policy. The same was also held in the very popular Indra Sahani case of the year 1992, that reservation is not a fundamental right. So first and second statements are correct. We go to the next question. Which of the following statements is or are correct? And it says rule of law is an absolute principle and principles of natural justice are absolute principles. Now, whenever such statements are made, hardly 30% of us could get that right. Generally there is no principle which is absolute. As you also say, no absolute truth, right? No black and white, no good or bad, perpetually. Contextually things can be a little different, so you should always think of these kind of statements with a doubt. And the point is, both of these, rule of law and the principles of natural justice, they both have certain exceptions. For example, rule of law, we all know Article 361, where the president or the governor both have been given immunities. Similarly, Article 105 and 194, where special privileges are given to the members of the legislatures. So legislators have that immunity. Similarly, principles of natural justice, offices which are offices of pleasure, such as the governor or attorney general of India or the ministers, and likewise, no hearing needs to be given. So audio alterum partem will not be followed for them. Anyway, both of these are wrong. They are not absolute principles. There are exceptions possible. Then, who was the first Indian to join the Indian civil service? Now, first it says Surendra Nath Tagore. Now, his uncle was Rabindranath Tagore. He's got nothing to do with services as such. He was more like a writer. Surendranath Banerjee, also known as Rashtraguru, he was the founding member of the Indian National Congress. I'm sure you know that. So again, nothing to do with civil services as such. Then Satyendranath Tagore, he was the brother of Rabindranath Tagore, father of Surendranath. So, first Indian civil servant, qualified in the year 1863 and joined in 1864. This is the correct answer. We found it, but still, Subhash Chandra Bose, the fourth option given to us, he did join the civil service in the 1920 exam. In fact, he had a rank 4 in that exam. However, in 1921 itself, during his probation, he resigned from the service in his probation period itself to join the freedom struggle. And I would also like to show you his resignation letter. Uh, See how the standard sign off used to be for bureaucrats. I have the honor to be, sir, your most obedient servant. And the signature, I always find it interesting how now we just say yours faithfully or sincerely, but that's how it used to be. So correct answer is Satyendranath Tagore. Always remember, the first Indian civil servant. Then, the next question: who among the following referred the civil servants of India as the steel frame of India? Options given are Warren Hastings. Now, he is the creator of the office of the district collector, but beyond that, his contribution is not really regarded as much. Cornwallis is known for the Cornwallis Code, which gave judicial powers to the collector. Uh, that's why he's called the father of civil services in India, Cornwallis. But he was not the one who referred steel frame of India. It was too early for them to realize that. Now, Vallabhbhai Patel, at a speech on 21st of April 1947 of the first batch of IAS officers at the Metcalfe House, that used to be the training place initially. And that's exactly the reason why the Civil Services Day is celebrated on 21st of April. He made that statement. However, actually, if you see the statement, it was originally made by a British Prime Minister by the name David Lloyd George. So, David Lloyd George in 1922 had made a statement saying that ICS is the steel frame of British administration in India. Sardar Patel had adapted it as steel frame of India. Fourth option is saying Nehru, though we know Vallabhbhai Patel, but see, Nehru would never say such things, as he was not in a big favor to continue with all India services. In fact, before independence, he used to mock the ICS as one very popular statement that ICS is neither Indian nor civil nor a service. Later on, so he agreed, but it was mainly because of Vallabhbhai Patel that all India services continued. And that's why Vallabhbhai Patel is called as the father of all India services. Let's go to the next question. It says, how many of the following services existed prior to independence of India? Now, first thing, it's a very poor performance. Only 17% know the history of all India services that we are aspiring for. Prior to the independence, various all India services have existed at different times, created and discontinued also, such as the Indian Civil Service that we know, or the Indian Police. These are the popular ones, from which the legacy continues as the IAS or the IPS. Then the Imperial Forest Service was there, Indian Medical Service was there, Indian Service for Engineers, Indian Agricultural Service, Indian Educational Service, then Indian Veterinary Service, and likewise among these, the Indian Service of Engineers, the Indian Forest Service, and the Indian Medical and Health Service. These three were created by an amendment in 1963 to the All India Services Act. So, an amendment was made, and these three services were created. However, finally, the notification was made only for the Forest Service. And those amendments were repealed also later in 1974. So, only Indian Forest Service finally got created, though there was proposal of Medical and Health Service as well as the Indian Service of Engineers as All India Services. Nevertheless, for this question, all three have existed earlier before independence. Then, When was the first function held to observe the Civil Services Day in India? We just saw that 21st of April every year is celebrated as the Civil Services Day. But the first time it was done was 2006, which is exactly 20 years from now. And this is organized by the Department of Administrative Reforms and Personal Grievances. So DARPG, a department which is under the Ministry of Personnel, Public Grievances and Pensions. Ministry of Personnel, Public Grievances and Pensions. So yeah, I think I said personal grievances here. Department of Administrative Reforms and Public Grievances. So this is the department which organizes this every year now. So it's been 20 years since we are doing this. Now, last question for today's video. The civil services examination was held in India for the first time in which year? So see, civil services examination, it started with the Macaulay's report. So when Macaulay was appointed, and in that report, he had recommended a merit-based civil service in India. And that was introduced finally in 1854. The report recommended a permanent civil service, which should be based on merit and competitive examinations. So, a civil services commission was appointed or set up in 1854 in London, and the competitive examinations were started from the year 1855. Initially, all of these exams will be conducted only in London. So the Indians at that time, they kept demanding to conduct the exam in India as well. It was only after the First World War, right? First World War, and the Montagu-Chelmsford reforms of the 1919, finally when the Government of India Act 1919 came, after the Montagu-Chelmsford reforms, that this was agreed. And from 1922, the Indian civil service examination began to be held in India also. First, it was in Allahabad, and later in Delhi when the Federal Public Service Commission was set up. And after independence, the training will be held at Metcalfe House, the picture of which you can see here, in Delhi, until around the 1960s, when it was finally shifted to the Lal Bahadur Shastri National Academy of Administration at Mussoorie. Correct answer is 1922. And that is all for this video. Keep working hard. All the best.